Greetings from Columbus, Ohio. Derek DeBross, attorney Derek DeBross from Munitions Law Group, munitionsgroup.com. You can find us on the web at munitionsgroup.com. Our information's on the screen. We handle anything regarding firearms, as simple as that. If you need any legal assistance or have a legal question regarding firearms, please give us a call. We'd be more than happy to help you. We have offices in Atlanta, Georgia, Louisville, Kentucky, and Columbus, Ohio. And we are licensed in several states and affiliate with attorneys in all 50 states. So please, again, give us a holler. Today on the Munitions Cache, we have a question from a Sawyer is his name or her name, as it may be. And the question reads as follows. I hope this is the right way to message you for a video topic. Obviously it was. Like I said, email. You can drop it in the comments below. Please do so. You can even send us smoke signals, send us a telegraph, whatever you want. We'll get the question. We'll put it in the cache and we'll make sure that we answer it for you at some point in the future. We try to get these videos out weekly. So hopefully it is. It was. I would love to know about concealed carrying with a felon in the vehicle. Occasionally, my coworker, who is a felon, has a right to, or has to ride in my personal truck with me where I have my loaded handgun. What is the correct way to go about this? So first off, I'm going to touch on the state versus federal issue. As always, I'm licensed in Ohio, working on getting licensed in Indiana and West Virginia and Kentucky. My law partner's licensed in Georgia as well as Kentucky, and we have some additional of counsel that's licensed in areas such as DC, Illinois, and Florida. So every state, that said, is different. And it's important to keep that in mind. But with regards to the broad strokes of your question, it really, what you're getting at is, am I aiding and abetting somebody in committing a federal crime if they're a felon? And for today's discussion, let's assume they can't have a gun. That's a whole nother discussion. In Ohio, technically, a felony 5 non-violent, non-drug-related felon can actually own guns. But that's for another day. So let's assume the felon, your friend, in fact, cannot possess a firearm under the 1968 Gun Control Act. And what that law says is if you've been convicted of a crime that had the potential for more than a year in prison, then you have a disability, as we say under the law, from possessing guns. So let's say that's the case with your friend and you're going to or from work, you have your concealed handgun on you, the friend's in the car. Again, it's a possession issue. And what the law defines possession as is dominion and control. The question really becomes, does that gentleman have dominion and control over the weapon? Say he's not touching it. Then it could become a question of constructive possession. Does that person have the power and intention to exercise dominion and control over the weapon? And again, these are all elements that the Assistant U.S. Attorney's Office would have to prove beyond a reasonable doubt in front of a jury if they're going to convict your friend. If they're able to do that, then we look to you as someone who aids and abets or is complicit in that crime, meaning you assisted in that crime and you intended to assist in that crime. The common scenario we hear is, hey, I have firearms, my loved one, my spouse, my girlfriend, boyfriend is convicted of a felony, can I live with them? Of course, you don't leave your Second Amendment rights at the door depending on who you decide to live or marry. The question becomes they can't possess the gun, right? So the general advice is you got to keep it locked up and throw away the key, but even that can be risky. You know, if ATF wanted to try to make a case out of it, the U.S. Department of Justice wanted to try and make a case out of it, they may very well be able to do that, or at least make it an attempt to. I think it would be very difficult to prove if you had evidence that you owned the safe, bought the safe, you were the one with the combination. It'd be very difficult for them to prove. So when we apply that to a car, my general recommendation across the board is that you have that gun on your person. Not only is it more tactical, because if you have to leave the car, the gun's on you, but it really kind of does away with the issue that this felon had possession or had constructive possession of the gun. I think it'd be a very difficult case to win. Now, that doesn't mean that they won't try to charge you. I think it'd be next to impossible for them to actually come up with a good legal argument if that gun was on your person clearly and he did not have the ability to touch the gun. But again, you know, keep all these dynamics in mind. It's not, unfortunately, a clear-cut issue as things in criminal world generally are not. So I hope that answers your question. To all my viewers, again, thank you for watching. Please drop your comments in the comments section. Hit the like button, subscribe, and be sure to hit that notification button. And as always, be safe and carry on.